So this is the Music Modernization Act breakout session. Maybe I should stand. I'm so short. I'm sorry, you guys. I'll stand just to introduce our panelists today. I'm delighted to welcome this group of people. I feel so pleased that each of them has accepted this invitation to come and be with us today. These are stellar people in this industry. First, right here to my right, we have Shannon Sorensen, who comes from us from Washington, D.C., but is a BYU law grad and a Provo native, so we're happy to welcome her back. She's VP of Government Affairs and Counsel at the National Music Publishers Association, which you'll learn is backing the Mechanical Licensing Collective, which is what we'll be talking about today. So a big deal, big get to have her here with us today. Next to her, we have Serona Elton, who comes to us from the University of Miami, Frost School of Music. Serona wears multiple hats in what she does over there. She is an associate professor, associate administration, dean of administration, and also the director of their music, business, and entertainment industries program at the School of Music there, the Frost School of Music. And in her spare time, because that's not enough for her to do, she also works with Warner Music Group as her VP of Product Management. And then here from BYU today, I'm so pleased to have Ron Saltmarsh with us here, which I hope some of you have met Ron and bumped into him here. Ron is a very talented guy. He's an award-winning songwriter, producer, recording engineer, performer, entrepreneur. You name it, he's done it. He's had quite the career in the music industry, and we're lucky to have been able to lure him back to BYU to be a professor here in the School of Music and to basically create, right, Ron? You created the commercial music division. So I'm so pleased that we can have these panelists here, and we're going to talk to you about the Music Modernization Act. We'll spend most of our time, there are 3 parts to the Music Modernization Act. We'll spend most of our time on the part dealing with the Music Modernization Act, the Musical Works Modernization Act, but we wanted to give you an overview of the major points of this historic legislation, and we're lucky to have people who were actually involved. Shannon was on the team that made this happen, so we're so happy. I can't express how delighted I am to bring this session to you. So with that, I will turn it over to Shannon to just give us a little bit of a music copyright primer.
Is that loud enough? Huh? To just hold it. Okay. Can we go to the chart? Okay, so who is familiar with the 2 copyrights in every song that you listen to? All right, good number, but we'll go through the chart anyway. So in every song that you hear, there are 2 different copyrights. There's the copyright in the musical composition, and there's the copyright in the sound recording. The copyright in the musical composition means the notes and lyrics, the music, like the tune, think what was written. And then the sound recording is a fixation of a particular performance of that musical composition. So any sound recording you hear, that's from one time that musical composition was performed, right? So those are the two separate rights, and the ones who typically write the musical compositions are composers, lyricists, songwriters, and then music publishers are their partners who work with them to administer their works and get them cut by record labels and etc. So on the sound recording side, you have artists, engineers, producers, and record labels. And in each of these rights, you have a couple of different. So copyright is a bundle of rights, right? So for each of these, there's a couple of different rights that they have. There's the rights of reproduction and distribution. There's right of public performance, and then at the bottom is sync rights. This is technically part of the reproduction and distribution right, but they're administered differently, and typically just have their own name, because sync means whenever you're putting it with a movie, whenever you're putting it with an advertisement or in a TV show or something like that. So that's the simplest one. Sync exists all in the free market. If you're going to put somebody's song in your movie or in your advertisement, you have to get the license from both the music publisher and the record label, and they are typically paid equally, both of the rights. So that's the simplest one. And then going back up to the top, reproduction and distribution. This is a little bit different for sound recordings as compared to musical works. For sound recordings, this exists in the free market they have complete authority over whether they want to, so traditionally this is, think a record label is allowed to make actual records or make CDs. They're the ones that are authorized to do that, and they can authorize other people to do that, but that's all within their purview. So in the modern age, this means that when a record label wants to pull all of their stuff off of Spotify or not have it on iTunes or whatever, they're allowed to do that. They can pull it off. So like Taylor Swift can decide not to release her album on Spotify until after it's had a while to have CD sales. That's all free market. So on the musical composition side, it's a little bit more complicated than that. The musical composition, rights of reproduction, and distribution can kind of be separated into these two buckets. One is the non-mechanical rights, which typically means like things like sheet music or posting lyrics online. And then the mechanical right is specifically the right to fix a musical composition in a phonorecord. So mechanical royalties started in the early 1900s when player piano companies would create music and then would say, well, you have to buy our piano if you want to play our songs. Congress was worried about this, and so they went and instituted a compulsory license, and they named this right the mechanical right, being a mechanical reproduction of your song. So this right is implicated in a lot of different areas today. This is typically so the mechanical right typically is, I lost my train of thought. So what we think of like with the mechanical right today, when you have the first use, record companies have to have authorized from the publisher to make the first reproduction of a song. After that, the musical composition owner no longer has a say over whether they're going to license a song or not. It's subject to compulsory license, meaning the government sets the rates. It's set by the Copyright Royalty Board, and you can't opt out. You can't say no. So when Spotify wants to use a song, they have to get authorization from the record label, but they have to license the work from the publisher and the songwriter. They don't have to get permission, though. They have to say yes. They have to pay them, but you're not allowed to say no. So that's sort of where that's music. That's mechanical licensing, and then the public performance space. The musical compositions have a really broad right of public performance. When your work is performed in a radio, in a concert, in a restaurant, every time a musical work is performed, you have a right of public performance. Sound recordings, on the other hand, only have a right of public performance in digital radio. So whenever a song is played over AM or FM radio or traditional broadcasting in a bar or a restaurant or at a concert, the musical composition owner is being paid, but the sound recording composition owner is not. In the late 1900s, I think in the 90s, when digital radio and satellite radio started coming up, the record label said, actually, we do want to get paid for this now. So Congress went ahead and gave them a right of public performance only in digital radio. So now sound recordings will get paid if it's played over Pandora or if it's played over Sirius XM, but they still are not being paid for AM, FM radio. So that's the chart. We'll refer back to a couple of these different buckets because MMA makes changes to a couple of these different areas. So that's music licensing in a nutshell.
So Shannon, I'm actually going to ask you to tell us a little bit about the Classics Act. This is one of the major parts of the Music Modernization Act. And these first two parts we'll probably breeze through in a few minutes and spend most of our time on the Musical Works Modernization Act.
Yes. So the Classics Act extended the right of public performance for sound recordings. So we're in this bucket under record labels and public performance. It extended the federal right of public performance for sound recordings to works that were recorded before 1972. So in 1972 is when Congress granted the public performance right to sound recordings for the first time, but they didn't want to institute it retroactively, so anything recorded before 72 had no right of public performance. The issue with this is, as digital radio was paying sound recording artists from post-72, there was a big market for playing the works that were recorded before 1972, but those were not being paid at all. So think SiriusXM if you're listening to 60s on 6 or 50s on 5. Those recording artists are not paid at all, whereas if you're listening to 80s on 8, everyone's getting paid. So the concern is for a lot of these aging recording artists, they're not actually getting paid for the ways in which a lot of their works were being used. So there's a really big market for digital radio for those kind of works, and they weren't getting any licenses at all, or they weren't getting any royalties at all. So what the Classics Act did is it didn't create a copyright retroactively, but it authorized, but it said that any unauthorized public performance of a pre-72 work would be treated like copyright infringement. So basically what that means is, though it's technically not a copyright, pre-72 works now have to be paid royalties when they're used. And the term is 95 years. So whenever it was first published, 95 years later, it will go into the public domain. But now pre-72 works have coverage, and now our favorites like the Supremes and folks like that who all had their works recorded before 1972 are getting paid, which is great.
For digital transmission only.
Only for digital transmission. Well, for interactive, yeah.
They've always had it.
For interactive, that's reproduction and distribution, and that's in the free market. But this is just for digital public performance royalties, like Pandora, like SiriusXM, like iHeartRadio. So that's the Classics Act.
Thank you, Shannon. So next we'll talk a little bit about the AMP Act, and Ron is our expert here, coming from the songwriting, your experience, Ron. This one's important to you because it has an impact on you personally, right?
I represent the blue-collar people in the music industry, the ones who create the content. When I reading through the MMA, I was kind of excited when I came across this, because in my career, I've worked as a songwriter, as an artist, as a producer, as a recording engineer. Many times I felt like what the people were hearing in the final recording was 80% me and 20% of the vocalist or the artist. When you guys hear a record on the radio, we all identify it with the artist, like Tim McGraw, and many people still today assume, well, Tim wrote that song. I mean, he sang it. He obviously wrote it. And the truth is 95% of your artists do not write their material. You have a songwriter that's writing that and providing this content. That song then, well, here, let me read this act, and then we'll describe why this is important. Why is this such a big deal? So Title III, among other things, allows music producers, mixers, sound engineers to receive royalties collected for uses of sound recordings under the Section 114 statutory license by formalizing a process wherein the designated collective, which is in this case a sound exchange, will distribute these royalties to parties under a letter of direction from the artist. All right, what does that mean? That means that the people who are actually responsible for the creation of a record are going to be able to have a legal right, a copyright, to receive money from the performances and mechanicals, the royalties that come from this. All right, let's talk about just a recording really quickly. So we have a songwriter who writes the song. That song gets pitched to an artist, a record label, a producer who decides that song is going to fit this artist really well. The record company hires a producer to oversee all the creative aspects of this recording. Everything from hiring the studio musicians, booking the studio, scheduling, all the money that has to transpire. And producers often take a very creative role in the production of the song, the arrangement, maybe some melodic ideas, okay? There's a big interest there of the producer. As a producer, an example, I'm just finishing working with a project with one of the original singers from Celtic Women. She's putting out her own solo record. On this record, I was a songwriter, the chief engineer and recording mixer, the producer, and studio musician. So when I hear this record, I hear a lot of me in it, okay? But my name's not, my name will go on the little CD cover, but you will hear this from Alex Sharp, okay, as the artist, who will receive, her share of the royalties and stuff. Unless it was written into the contract with my recording company, I will receive no back-end money. I won't receive any royalties. I'll just get the money that I was paid initially to produce this project. Some of your bigger producers were able to negotiate with record companies what they call points in order to have some royalties paid back to them for their work and their effort. Of course, you can see what the incentive would be is the producer is going to go above and beyond if he or she has a stake in this project to make it really sell well. So this provision provides that flow back to these creative people. The recording engineer is responsible for sonically what you're hearing. They take all the instruments, the vocals, they balance them, how much you're going to hear of this, how much you're going to hear of that, and they create this sonic palette, this picture of music that you hear. And the producer, as I said, is in charge of overseeing this entire production. So as a producer, as a recording engineer, this is exciting to me and, in my opinion, long overdue. That's the AMP Act.
Thank you, Ron. So what I neglected to mention, and Shannon and Serona, you guys can all talk a little bit more about this, but this Music Modernization Act was an unprecedented cooperation among people who you wouldn't think would agree. They all rallied and came together and made compromises so that these things could happen. So these three different titles, these three different parts ended up being consolidated into one bill that was just signed into law in October of last year. And there's a lot of work to be done, and that's really where we're going to spend some of the rest of our time in what it actually means going forward. But when Ron talks about the real-world implication that he's going to experience as a producer, producers, mixers, sounds, and engineers, they relied on their contractual agreements and kind of the mercy of the record labels, whether they were going to get a cut of their work and their contribution to these recordings, which of course we hear it and we love it and it's amazing, and we sometimes don't remember how much work actually went into that, how many people actually participated in that. And so the AMP Act in particular is a very exciting development that was able to get across the finish line. So next I'll ask Serona to tell us a little bit more about the big meat of this act, the Music Works Modernization Act. Serona, can you tell us just kind of what was life before the Music Works Modernization Act? How did mechanical licensing work? What were some problems? What were some issues? Why was it so important that this moved forward?
Well, I would describe it as complicated and inefficient. Now, it might be a little less complicated and maybe a little more efficient, but still, I don't know if we go all the way to saying something like streamlined and simple. So I don't think it'll ever be that. So complicated and cumbersome. In the U.S., which I should point out is not the same, this process is not the same in other countries. And the U.S. is interesting how rarely we're willing to look at how other countries solve some of these problems. It's just I guess it's a U.S. thing. But the process of mechanical licensing in the United States has always been what we call a work by work, you could almost call it a share by share process. And what that means is if you take the traditional model of a record company putting out a record, and say an album, the record company would have to find out for every song that they've made a record of who all the songwriters of that song are, would have to find out who the music publisher is for each of those songwriters, would have to connect with all of those music publishers to see how they all agree to divide up the 100% of that song. We call those the splits or the shares, who wrote what percentage of it, get them all to agree, and then make sure you have a license in place from these different, publishers, which can come in a couple different forms. And then pay each of them their relative amount of money per, share for a sale, let's say. So imagine that now at scale, right? Imagine that. I think one of the top songs of the year, the Grammys about a year ago or something, maybe had more than 7 songwriters on it. It's pretty common to have at least that many or more, particularly in the urban genres. And that process of trying to find out every single rights holder in that song, connect with all of them directly, is a cumbersome process. And so that's how it's been for a very long time. Now, some of you might have heard of an entity, the Harry Fox Agency. They have been around a long time, and in some cases, they administer part or all of a song. And when that happens, that does help make things more efficient. But there's still a huge percentage of songs out there or shares on songs out there the Harry Fox Agency doesn't administer, in which case the record company has had to go straight to that publisher. There's a whole nother process called a compulsory license, which is what the Music Modernization Act addresses. But it's worth pointing out to those of you who might think that everything has always just followed the compulsory licensing process. That's not true. The vast majority of mechanical licensing is done on a voluntary basis, where the record company contacts the music publisher, the publisher agrees to grant a license, and they move forward from that. Or the recording artist has already granted a license in their recording agreement for the shares of the songs that they end up writing. So the process generally does not rely on the compulsory approach that the law establishes. And in some cases, the compulsory approach has never even been available. And I actually think the availability of the compulsory approach is a big reason why we have some of the change we have in the law today. For that compulsory process to kick in, the song has had to already have been recorded with permission of the music publisher and then distributed in the United States in phono records to the public for their private use. So you guys know this of thinking of, the next use of a song might be what we call a cover record. So let's say it's originally written and recorded by somebody, and after it's out there in the marketplace, somebody else makes a recording of that song. We refer to that as a cover record, although the copyright law doesn't use that terminology. So the compulsory license doesn't even kick in, or didn't kick in, until a musical work was recorded and distributed to the public. And so imagine now, fast forward, and we're in a new world, and you have a digital service provider trying to get these licenses in place for hundreds of thousands, if not millions, of musical works. And it's beyond to imagine they would have an army of people trying to track down the particular publisher share on every single song. I will tell you that all the record companies, major record companies, have huge staffs, more than 50 people easily at each one of those companies that do exactly that. But it's not efficient, and it means a lot of things fall through the cracks. So imagine that at scale, and then imagine that in today's world where a record is put out on a streaming service, I say record to mean recording. I don't mean a physical record, but a brand new recording by, Drake goes out in a streaming service before there is ever a CD or a vinyl or a download. And so the first distribution to the public is on a streaming service. And what that has meant is that a streaming service can't get a compulsory license if they are the first use. So all these kind of inefficiencies and complicated nuances of the law around what is a first use, what isn't a first use, all those kinds of things contributed to a very inefficient, complicated process that was just fraught with problems, and no matter what, you were going to screw it up somehow. And so, there was no centralized service. The big digital services hired a couple of different entities. Harry Fox Agency is one of them. Music Reports is another. Sort of the leading entities that understand this and provide a service to companies in the United States, both of which are not perfect. Hired them, did get a lot of licenses, paid a lot of people, didn't pay a lot of other people. That resulted in a number of really big lawsuits. It's amazing how really big lawsuits bring parties to the table to negotiate on some improvements to the law. It's amazing how that happens. So inefficient process. And so as these big lawsuits started happening, my understanding, and any of you feel free to correct me, the big digital music services, I think all along were trying to, figure out how to balance this risk that they were undertaking. And, there was always this kind of, well, do we get a voluntary license? Do we try to get a compulsory license? And if we were going to get a compulsory license, assuming it was even available for this particular recording, How would we do that? You know, the copyright law establishes the process of getting a compulsory license. There's a notice requirement. You have to send notice to the owners of that musical work. If you can't find them after you've made a diligent search of the public records of the Copyright Office, then you could file a notice to the Copyright Office, a notice of intent. You could file it with the Copyright Office, and then you did not have the obligation to pay royalties to the owner of that musical work until they finally registered with the Copyright Office. And so complicated, I'm oversimplifying. I'm sure some of you are cringing a little. It's not exactly right, but it's probably the best I can do in this short few minutes. And so that process, though, was prohibitive because there was a significant fee, significant at scale, to pay to file these with the Copyright Office, every one of them, for every single song, you know, imagining hundreds of thousands of songs. Well, the Copyright Office changed the process and said, actually, you know, now you could just pay this fee and submit many, many songs all in one filing. And it totally changed the economics around being able to file a notice of intention with the Copyright Office. Soon after they did that, all the major DSPs filed these massive NOIs, notice of intentions, with the Copyright Office, millions and millions of lines of data. So much so that SoundExchange even built a tool so that you as a songwriter or publisher could search those files of data to find your works, because it was way beyond something you could do on your computer. So it's interesting. It was a bit of a, it feels like a bit of a hedge of liability there, because they were also still going through processes with like the Harry Fox Agency to find people and pay them. So even when they would file that with the Copyright Office, they were still also pursuing mechanical licensing. It was a bit of a fallback, you know, sort of stopgap. Just not efficient. Nobody was happy with that. I would argue the DSPs were not happy with it. Publishers were not happy with it. I don't think anybody was happy with it. I don't think the Copyright Office was happy with it. And so, you know, you had a lot of unhappiness with that. You had these large lawsuits. I think a lot of that is what all brought all the right parties to the table to finally, you know, and let's be clear, they negotiated this and then presented it on some level to Congress. Congress has never wanted to get in the middle of complicated music industry copyright disputes between different parts of the music industry. I mean, imagine trying to explain that to some congressman from some place.
It's hard.
And they're never going to get in there and take a side. Like, they're not going to go, well, I side with record companies on this and I side with publishers. They're going to be like, you guys figure it all out. And once you figured it all out, come back to us and then talk to us. So this would not have happened but for all of the work put in between, you know, the parties that were most impacted by this, hammering out the details before it ever showed up on Capitol Hill. So that's probably a quick version. So the last point then is the rate setting. So for compulsory licenses, the Copyright Royalty Board would set a rate. The way they went about setting that rate has been adjusted. It was a 4-factor test that was heavily based on policy and concepts of fairness and lack of disruption to an industry. Even though I actually read a quote from David Israelite about that the Section 115, which is what Mechanicals is addressing, rates have not generally been set in an unfair way, but they did not use a willing buyer, willing seller standard, which is what everybody was advocating for. So there was a change in the way the rates will be set in the future in terms of what the judges can consider. I don't know how radically different that will get. I also read that the perspective is that they would always start with an analysis of kind of some benchmarks and then go from there, but this would prevent them, the CRB, from coming up with a rate that's lower than a fair market rate. So that's the, you know, it was messy, ugly, everybody hated it, inefficient, complicated, you're so likely to get it wrong, lots of risk. That's the quick version of before.
Thank you, Sirona. So I think you've painted a great picture. Now, Shannon, you tell us how you solved all of that. How did that all work out?
I solved it. No, I think Sirona hit the nail on the head. What happened was, after so many lawsuits where our organization was, you know, litigating with Spotify for years and years over unmatched works and works that had wrongly been filed for the rateless license at the Copyright Office when actually the information was there. And I mean, for us, one of the big things was getting rid of the rateless license and changing the rate standard to the willing buyer, willing seller. And for the digital services, I think they were ready to not have such massive liabilities. There wasn't really an effective way to avoid that liability, though, with how complicated it was. So what they wanted was some shield from liability in exchange for, what they wanted was a shield from liability for these infringement suits, and what we wanted was to be paid accurately and fairly and quickly and not have rateless licenses filed with the Copyright Office. So we worked with Spotify and Apple Music and Amazon, and there's another one that I'm blanking on now.
No, well, Pandora is mostly non-interactive.
They just
have
launched their interactive.
they
like
do have
a
an
year
interactive
ago.
service, but I don't think they were
like
a
quieter
major.
in the
Google has an audio streaming service.
Google Play. Yes.
It's important to understand this is not video. We'll come back to that in a minute. This is all audio only.
Yeah. So Congressman Goodlatte, who is the chair of the House Judiciary Committee, had been undertaking this copyright review for a long time and wanted to fix some of these problems, but really we got the directive to just figure it out and then bring us something fully baked. So under Congressman Doug Collins, who is now the ranking member of the Judiciary Committee, he was really the one that shepherded the groups and forced us all in a room and made us hammer out all of this, and it took surprisingly short amount of time for such a big bill to get through. The Music Modernization Act was introduced, I think, February of 2017, and or February 2018, and it was.
I think it was. I thought it was earlier than that.
It was earlier than that. It was. I think it was in 17. Or it was, oh no, sorry. It was introduced December of 2017, and it was all signed into law a year ago today, actually, which is a pretty fast timeline for something this big. But I think it was due to how complicated it was really ripe for a solution, and everyone had big enough issues that they were willing to make compromises. So I can't take a lot of personal credit for it, but.
So what are the compromises? So what does it look like now? Going forward, what will it look like to obtain mechanical licensing? What will it look like for Spotify and Google Play and our songwriters? How will they be paid? And what are some of the solutions that were reached?
Sirona can probably speak better to how the licensing will impact digital services and record and music publishers, but some of the compromises that were made. So the MMA, the big thing is that it creates a mechanical licensing collective that will offer blanket licenses, so digital services can get a license for everything that they need to play, and in turn, the digital services are paying for the mechanical licensing collective so that there is not a commission taken out of songwriters and publishers' royalties. Hopefully it goes well. We're in the process of setting it up now, but what the idea was is that we'd both get all of our problems solved. We'd all be paid 100% of the royalties, and they would not have to, we wouldn't have to be in court anymore. So that was the big compromise that got everyone on board. And then the other big aspect of that is that music publishers didn't want to give up this big chunk of their business, who traditionally have done mechanical licensing. That's one of their, biggest revenue streams as music publishers. So what we didn't want is to not be in control of that process anymore. So the MLC is going to be run by music publishers and songwriters, which was a huge win for our industry.
So the law actually lays out a lot of rules about how the digital service providers, what they have to do in order to be, to receive this blanket license, which is a weird thing because in the terminology, the industry, those of us in there, we talk about the ASCAP, BMI, CSAC, global music rights licenses being blanket. And then we talk about Section 115 as being compulsory. This is a strange kind of hybrid-y, blanket-y, compulsory kind of a thing, where the blanket piece has to do with it stops them having to do this work-by-work permission process. But there still is a process of knowing exactly what work was streamed, how many times, and that money will very specifically get back to those writers, whereas a lot of the way, your performing rights organizations operate under blanket is a little less specific. That one radio play in Miami on a FM station doesn't necessarily generate an exact amount to those songwriters. So this still follows a work-by-work, share-by-share data processing sort of approach. But the way the service providers get to interact with the MLC is not to have to track down each one and ask for separate permission. They get to, as long as they comply with these rules, they get this blanket license from the MLC. So it also means there will be no more filing NOIs on the Copyright Office. That is gone. Not just the royalty-free piece, but the whole filing process of them goes away. But there are some hoops that the digital service providers still have to operate under, and some obligations about what data they have to provide, and some so it's a lot more straightforward and simple than what happened before. But it's not as it's not like a single button, kind of push a button and you're good, just send the MLC a bunch of money and they'll figure it out. It's not quite that simple. So yeah, those are, we can get into some more nitty gritty things, but that's one of the biggest changes. Do you want me to just go right into the things it doesn't talk about? The open questions?
One more thing, just to clarify for the audience. So how will the rates setting be different now for, the royalty rates? Now that with the Mechanical Licensing Collective, how are those rates going to be determined?
So the mechanical royalty rates are always, that's still going to go through the same process of going through the Copyright Royalty Board, and that's our organization, the National Music Publishers Association, who litigates those rate setting lawsuits. But now, rather than using this outdated 801B test that took into account all of these different factors and balanced, it's kind of this 4-part balancing test, now we'll be using the willing buyer, willing seller test. So hopefully the rates will also increase under willing buyer, willing seller.
And that means that you get to look at other, correct me if I'm wrong, this is an area I'm not as familiar with. You get to look and see at what is Spotify paying the record company.
Yeah.
And which everybody knows is an order of magnitude more than the mechanicals. So now that gets to enter the conversation in a way that it have more influence in that kind of decision than it used to.
Yeah.
So for Ron, that means he's going to be, hopefully what he's going to see in his bank account is going to gain more parity with what the artists are seeing from the same type of contributions that they're making.
I think parity is a way off. Parity, but something that is more than now.
More. They can at least consider what the artists are making now when we're making those determinations for what's gonna be paid to the songwriters.
It's a factor.
Yeah,
it will be considered.
So Serona, tell us now, what are some questions going forward? This is a huge undertaking. What are some of the issues that have to be dealt with? We know that the Mechanical Licensing Collective is supposed to be launching in January next year. What are some of the things that we're all gonna face as we go forward?
Well, I think the law does specify a lot of things, like the MLC must do this and the DSP must do that. There's still a lot of questions about sort of day-to-day operations and who's going to do what that I think still have to be ironed out, and they will be. But there's also a couple of key things that I think people need to understand. So some folks think this is going to change all mechanical licensing. It's all going to be easy. It's all going to be streamlined. It's all going through the central hub. Well, you might be shocked to know that nothing having to do with physical products is going through the MLC. Yeah. So I know physical, in terms of CD vinyl, it's no question it's a declining business, but it's not zero yet. And certainly from a major record perspective, but as soon as you're going to put it out, the work is still the same. So this is the key. The work involved to do mechanical licensing for a CD or vinyl is exactly the same if you sell 100 units or 1,000 or 100,000. So the volume of sales is declining, but until record companies stop creating them at all, like don't do it at all, there is still a mechanical licensing obligation. And as bad as it's doing, I promise you Drake is selling a lot of vinyl. A lot, how you define a lot, more than 10. So that process has to continue running separate from the MLC. This is my opinion. I think that's inefficient. That was a change that got pushed forward into the law towards the end of its time in being crafted. As a person who does this kind of work at a record company, I disclose my bias. I think that's not great for efficiencies to have multiple processes running in parallel. It would have been amazing for this entity to also absorb everything for physical, because guess what? It's the same recordings and the same songs and the same people getting paid, but it can't do that. It is limited to only digital. So that's something to understand. So there might be great efficiencies gained on the audio, on-demand audio-only streaming, and it can do downloads. Up until this point, from a major record company point of view, downloads still go through the record companies. That might shift. It's allowable. It can't do physical. It also cannot do video. And so we haven't talked about video at all. We don't use the word mechanical for videos. It's a synchronization, but even in the world of synchronization, you probably want to mentally split yourself between thinking about use of music and film and TV, and it's combined that way versus a straight up old-fashioned, for those of you who remember MTV, I can't even use that reference with my students anymore. And they're like, I don't know what that means. When I say, like an MTV music video, they're like, what? Where it's just the one song and it's the same, basically audio recording for the whole video. Those have to follow yet a different process that also cannot go through the MLC. So guess what? It's the same song and the same recording made into a video, same publisher, same record, same songwriters, usually. Almost always, except for the one, there'll be some weird thing that says, for video, pay this guy, and audio, pay that guy. But so that's also going to have a separate path that goes on. There's no central entity for that. YouTube will deal with the publishers one way, and Facebook might a different way, and Apple might a different way for video. And so I was just hoping that, maybe it would be broader so that all that kind of stuff goes through one place. It doesn't. So that's just something to know. One of the most complicated things in all of this is the matching. You might hear the word matching. Matching the song to the recording, right? It's a data thing. It is a data thing, but it's saying I've got information about this recording. I know who the artist is. I know who the record company is. I have information about this musical work. I know who the songwriters are, who the music publishers are. Which musical work exactly was this recording based on? Because title's not enough, for example. This could have been a remix that included a remixer who was given a songwriting credit because they really shook it all up. And so it's a different musical work. And imagine you're the remixer that was granted a share of that song, 10% of the musical work that was made into the remix, and all the streaming revenue from that particular recording goes to the wrong song participants, right? So this whole exercise of matching is really complicated, especially for brand new musical works that are effectively composed while they're being recorded. So, you always think, well, it's easy, right? I'm going to make a recording. I can go look up this data on the Harry Fox website or the Performing Rights Organization website. No, you can't. It won't be there yet. The music publishers may not even know that their writers wrote this song in the studio yet. And so you end up with a chicken and egg thing, like, well, why can't you just associate the recording with the musical work? Well, because the musical work doesn't exist in anybody's system yet. So you get into this timing of who knows what and when, how to make these connections, and it's the connection that makes that money flow. So when Spotify reports information to the MLC, and they're going to report recording information and the identifier for the recording, when the MLC takes that data in, if the MLC doesn't know exactly which musical work that recording was based on, they can't pay people. So that's been the heavy lift in this industry for a long, long time. Who can make these authoritative links? Who can say for certain this recording is based on this musical work? That's been one of the biggest challenges. Like we have, it hasn't been an information system problem in this area of the industry. It's been who has to do that? Who has to spend the time, the money, and make it happen? So it's going to be, the MLC has a huge obligation to do this, but guess what? They don't have a magic wand. And so the things that have made it difficult up to this point are going to make it difficult for them too. So it's not clear how they're going to, necessarily be able to fix problems that a lot of, different industry entities haven't been able to yet. So big questions, I think, there. And then one other thing I think that could be a really good thing, or would be a good thing, is this central repository that's available to the public to search. I think it can help other licensing activity in the sense that if you are making a small indie film and you want to use some recording, as you want to go and ask for a sync license, you have the money, you have the wherewithal, you want to go and request it, you don't know who owns the recording. You can look that up in this. You don't know who owns the song. You could look that up in this. So while this database is not going to facilitate that other kind of licensing, it can help parties who need to go and get those licenses figure out who to go and ask, which I know is one of the hurdles for, particularly smaller entities trying to get these licenses. They want to do the right thing. They don't know who to, how to reach out. So I think that will be a good thing of this public database. So those are some things we'll have to see how they all play out.
So thank you. I want to leave some time for questions for our audience, but I guess everybody, just your takeaway, parting thoughts on the Music Modernization Act. Any final thoughts for the audience? For me, I would just, I think the U.S., I forget who it was who said it, but someone from the U.S. Copyright Office, I think, that noted something about this being the most significant reform to copyright law in decades, I want to say. So it represents quite an achievement, and even so, there's still a lot of work to be done.
So, I lived in Nashville from 1991 to 2001. Coolest thing I got to do on a daily basis, I had my studio right at the top of Music Row. I could walk down 16th Avenue and I could hear songwriters in their writing rooms creating all this great music. You just walk down, you could hear it flowing out of these buildings, these staff writers and stuff that existed at these publishing companies and these houses. It was the coolest thing to do. It inspired me. That's gone. That doesn't exist anymore. With the change in distribution, how we consume music, these laws didn't keep up with any of that. And what we as songwriters depended upon, what publishers depended upon to pay their songwriters and stuff, were these royalties from, it's very easy. You sell a CD, there's a cost to that, and there were fixed numbers, like you count on 5 cents a song per CD that was sold to come back and then get distributed. All of a sudden, the digital realm took over, and nobody knew what to do. All of a sudden, record labels weren't in charge anymore of their distribution and became these digital streaming services. And then it became this real big confusion. Well, what should we be paying? Where are the rights? I mean, we talked about kind of the confusion that existed. Well, the bottom line is the royalties stopped flowing. And publishers disbanded with their songwriters and only kept their big hit songwriters on staff. And I had dozens of friends who were songwriters for a living that are now selling cars or doing something different because the money to sustain them is no longer there. Hopefully, this act and all the things that we're discussing here will move to at least increase that royalty stream again, so we can start having, instead of these factories of songwriters that are producing 80% of what you're hearing on the radio today, the more creative songwriters, more people can get back into this industry, creating, and the money will be there to sustain them. That's from the bottom level. That's what we're looking up, hoping this will help reestablish that for jobs.
I'm very excited, enthusiastic about it. I wish it had gone a little further. As somebody who lives deep in the trenches of the nitty-gritty, as I kind of explained already. So I think I feel very, very enthusiastic, very excited about it. I think, there's some interesting challenges the industry has in terms of the long tail. The barriers to entry to this industry have changed radically in the last, 10, 15 years. And now anybody can get their music out there onto a service. But what that doesn't mean is that they understand how to set up their data. They understand all the business rules that go with that. And so, it's a weird field, right? Where just, people who aren't business people, who don't actually have a company and a staff, can put their product in the marketplace. That's not true in many other products that we deal with. I can't just spin up a brand new bottled water company tomorrow and expect it to be on shelves in the stores. It doesn't work that way. And so that means that some of the practices that could be complicated, cumbersome before, that companies, record companies, publishing companies were set up to handle, as much as they should have been better at it, they kind of break down when the floodgates are open. And so, I feel pretty confident that Ed Sheeran as a songwriter was getting paid for his streams on Spotify. I don't know that the little guy in the room somewhere else who put up his own music through something like DistroKid and handles his own publishing because he wrote that song was getting paid. That's the person who really was losing out. And so I think that population are probably going to feel the bigger impact than, the Ed Sheerans of the world, who still might feel something better, but I promise you he was getting his money. I feel very confident about that. So it is really a win for that sort of middle class creator who doesn't have a big company behind them to sort the stuff out.
Echoing what you guys are saying, I think I think we're really hoping to see big changes for songwriters, not only through the rate standard change and hopefully getting those royalties back up. It will be really hard to get royalties back up to where they were, when we're selling CDs and vinyl, but hopefully we can start moving in that direction. And we're already seeing some positive signs from the Copyright Royalty Board with our most recent rate setting procedure that was still under the 801B standard. We got a 50% increase in royalties over the next 5 years. So we're hoping to continue that growth from there and capitalize on willing buyer, willing seller, and really try to get, at least mimic free market rates for songwriters. And another thing that the MLC is going to do for songwriters is give them a way to interact directly and to go in and claim your royalties, which right now there's a big problem with unmatched royalties where Spotify and Amazon, Google Play, they're all just holding royalties for songs that they haven't been able to match. Those will get put back into the industry, claimed by their rightful owners, and then after a certain number of years, if they're not claimed, they'll be distributed to everybody. So I think what we're looking at is a much more transparent model, not having all of this data be proprietary, but having it be accessible and searchable. And, I think centralizing all of the data in one place will hopefully iron out some of the issues that we've had with having to do all of the matching at different, at HFA, but also Google had their own vendor and Amazon had a different vendor. And so if we're centralizing all of the matching, hopefully we'll be able to find more people and get them paid better. So looking forward to the next have an MLC set up.
Thank you. Does anyone have questions for our audience? Go ahead. Sorry, I don't know if we have a mic going, but Bill, why don't you go first?
Okay. So first of all, I wanted to plug the conference that I put on with the Copyright Society. It's going to be January 15th, Wednesday in New York. We're going to have a session put on by the MLC, who are going to talk about how they're doing and implementing this thing. So it should be, this is like hot off the presses as of a few days ago. I don't know who's going to be speaking yet, but it should be very informative. David Israelite is our keynote speaker. So that's one thing I wanted to mention. The other thing I wanted to mention is, and Saroni did a great job of talking about all the data issues, but there's one type of data that no one in my understanding has talked about, which is all of this discussion is about musical works. About, by my rough estimate, 1% of the catalogs of the streaming services are not musical works. They are comedy and other stuff. And those recordings, let's take comedy as an example, have copyrighted works underlying them, text works, if you will. And what the Spotifys of the world are going to do is they're going to send all this play count data to the MLC that's going to include sound recordings of non-musical works. No one that I've spoken to has any idea what's going to happen with that stuff. And 1% of 40, 50 million item catalog, that's still a lot of content. So I'm wondering if anyone has come across that situation at all.
I haven't, and it's such a great point. So one of the things to keep in mind about the Spotifys of the world is how they get their content in the first place. Generally, they're getting it from the content owner in terms of the recording. So, they get a feed from record companies. It's coming from the content owner. So what I would wonder, it seems like it might be in the best interest of a digital service to be able to separate out in that feed what involves a musical work and what doesn't. Because if it doesn't, that could be part of the data stream.
Pain in the rear end.
Well, but the alternative is though, then they are going to pay mechanical licensing on things that they don't need to. Because there is no mechanical, like if it's a comedian and they made their own recording of something, then it's a sound recording that it doesn't have a mechanical embedded in it necessarily. So there is no mechanical. It would be all lumped into that money due for the use of that recording. So it would seem to me, same thing with podcasts and everything else, it would seem to me that it's in the interest of the DSP to be able to say, these things I do not have a mechanical obligation on at all. My financial obligation is just to the sound recording owner, and therefore I don't have to pay the MLC for that, and therefore. But it's they would have to know that coming in. They'd have to know this track is a musical work, involves a musical work, this one doesn't. What I can tell you is, record companies have that information in their systems, because sometimes they'll put out something that's a comedy album or something else, and you indicate on the recording, does this embed a musical work or not? But again, once the floodgates are open, trying to get people to behave a certain way with their data is like herding cats, right? Or harder. So great question.
Sorry.
I just wanted to mention the URL for the conference. Okay, you can see me, but it's copyrightandtechconf.com.
Conf, ending at the F.
Right here in front of Bill.
Yeah.
Go ahead.
Mine's just a technical question. So, with mechanical licenses, a lot of music now is electronically produced. So there's not really sheet music to go with it. It's recorded as it's created. How does that work?
Still a composition.
Okay.
You don't need to be able to put it on sheet music for it to be a composition. Still a composition, no difference.
Go ahead.
So, a question about the ownership and the matching and ownership issues. The music business being what it is, people don't always agree, especially if they're writing music in the studio, as to who owns what share. And the matching and the cooperative only affects the rights that it has the right to administer. It's not all of the rights in the musical composition.
No, but it will be. So that's what the law actually establishes, that you don't get to, as a songwriter, opt out of going through the MLC.
All right.
Okay.
I'm asking a different question.
Okay.
So, are there preemptive effects of the dispute ownership resolution mechanism, not just for purposes, I would assume it is for their specific purposes, but what I meant was there are other rights in a composition besides the right to create phono records. What happens if the songwriters have a file a dispute in state court in Utah, and a Utah judge decides, well, this person owns this person owns that. Does that have any preemptive effect on the MLC's matching and ownership allocations? Are they bound by anything? Does it run the other way? Is there issue preclusion? Or are we going to have the possibility of different tribunals, if you will, deciding ownership differently for the same musical work?
So part of the MMA, the MLC is required to have a dispute resolution committee in the event that the very likely event that there are disputes over ownership. At the end of the day, if a court decides who owns what percentage, that stands. The MLC doesn't have the authority to decide the percentages. The MLC is authorized to help facilitate conversations between the songwriters and help facilitate
like a mediator.
disputes. Yeah, but at the end of the day, will not have ultimate authority to determine the splits. It is authorized under the MMA to hold contested funds, though, until those disputes are resolved.
Which will end up in tens of millions, I promise you. Major record companies have been holding many millions in legal disputes, and you have to have mechanisms that say we're only going to hold it for so long. If this lawsuit's abandoned, at what point do you release a legal hold? But especially some of the most valuable songs have disputes because there's so much money at stake.
Yeah.
So that problem, for example, is not going away.
So maybe one more question if there's. Sorry.
Either.
Go ahead.
Mine's
Right
real
here.
quick.
Okay.
I'm just really curious, how do you think this is going to affect the end user? Are they different pricing? Is the prices going to go up? Do you think it's going to be so? I mean, I know the mechanics of it are going to be very transparent to an end user, but are costs going to go up because there's a lot more money coming out from, or I'm just being naive?
It's a good question. I got asked that question a lot when we took this bill to the Hill. The one thing I will say is think about how much you pay for music now as compared to 10 years ago. Think about when you used to buy CDs and how much more expensive that is than getting a streaming service. So even if it does increase cost for the end user, and it's certainly possible that as rates increase that that end user costs will go up. I would be surprised if we saw really massive increases for end users anytime soon. But on the whole, music is really affordable right now, and I think that's a good thing, and we want to keep it that way, and we want, we wanted streaming services to be able to offer these music and to get out of their liability. So I don't know what their end calculation is going to be now that they don't have to go through all of these settlements and big lawsuits, whether they're actually going to have to increase costs because have to increase subscription costs because their costs are going to be lower. So we'll see.
I'm sorry, that's all the time we have, but we do have a networking break in the atrium just outside the ballroom. But please join me in thanking our panelists.